Welcome back to the Constitutional Clarion. This video is about Section 44 of the Constitution, which was controversial some years back in Australia. I wasn't intending to do a video about it, but it's something that I've been asked quite a lot about this morning because of a controversy, and I thought, well, if journalists are asking me about it, maybe you too might be interested. So, here goes. For those of you who are watching from overseas and need a little bit of context, it is as follows. Senator Payman was elected as a Labor Party senator for Western Australia at the last election in 2022. Section 44(1) of the Constitution, however, says that a citizen of a foreign power shall be incapable of being chosen or of sitting as a senator. At the time that she was elected, Senator Payman was a dual citizen of Australia and Afghanistan, and therefore a citizen of a foreign power. In her candidate nomination checklist, Senator Payman declared this, but she noted that after the Taliban came to power in Afghanistan, she approached the Afghanistan embassy in October 2021 to renounce her Afghan citizenship. She said that she was told in November 2021 that she had submitted the necessary documentation to the embassy, but that it had no communication with the new Taliban government in Afghanistan, and that her application for renunciation could therefore not be finalised in Kabul as required under the pre-Taliban law of Afghanistan. Senator Payman said that she had received legal advice confirming that, in light of the situation in Afghanistan and the impossibility of progressing her application to renounce Afghan citizenship, she was not disqualified and she could nominate as a candidate. Recently, Senator Payman resigned from the Labor Party and she proposes to continue her 6-year term in the Senate as an independent. If, however, Senator Payman was disqualified at the time that she nominated as a candidate in 2022, then there would be a recount, and it appears, and I haven't done the numbers myself, but I just read this in the newspaper, it appears that the seat would go to the next Labor candidate. If, on the other hand, she was validly elected, but circumstances changed, causing her later to become disqualified, then there would be a casual vacancy under Section 15 of the Constitution, which would be filled by a person nominated by Labor, because at the time she was elected, she was an endorsed candidate of the Labor Party. Hence, some members of the Labor Party, who presumably supported her eligibility in the past, now suggest that she is disqualified. This video explains the position of the High Court as the Court of Disputed Returns in relation to disqualification in such circumstances, whether this might be affected by changed circumstances, and also how this matter could actually get before a court. On its face, you would think that Senator Payman would be disqualified because she remains a citizen of a foreign power, contrary to the requirements of Section 44(1). But back in 1992, in the case of Sykes and Cleary, the High Court qualified its interpretation of Section 44(1). It pointed out that citizenship is determined according to the law of the foreign country concerned. But this would mean then that Australian citizens could be disqualified from standing for Parliament because citizenship was imposed involuntarily on them by a foreign law, and it could be made so that they weren't able to renounce it. 3 of the judges in the case noted that it, quote, would be wrong to interpret the constitutional provision in such a way as to disbar an Australian citizen who had taken all reasonable steps to divest himself or herself of any conflicting allegiance, unquote. Justice Dawson added that, quote, Section 44(1) should not be given a construction that would unreasonably result in some Australian citizens being irremediably incapable of being elected to either house of the Commonwealth Parliament, unquote. Now, this issue arose again in 2018 in the case of Re Gallagher concerning the disqualification of Senator Katie Gallagher. She had taken all necessary steps to renounce British citizenship before nominating for election, but had not had her renunciation processed by the United Kingdom before the nomination date. Were her actions enough? The court said they were not, because the British law did not irremediably prevent her from standing for Parliament. A joint judgment of 5 judges said that the mere fact that the renunciation process would take time and involve the exercise of discretion in a foreign country was not enough to establish an irremediable impediment. They said that the foreign law, quote, must present something of an insurmountable obstacle, such as a requirement with which compliance is not possible, unquote. They referred to an example given in an earlier case where necessary steps could not be taken because it would put the person at risk. Justice Edelman added that an example of this would be having to undertake a year's military service in the country during a war in order to be able to later renounce citizenship. Where there was no irremediable impediment, the person just had to wait until the renunciation process was completed in the other country before nominating, even if that meant that the person was not able to nominate for a particular election in Australia. But the court did not address whether potential delays of years or maybe even decades could turn into an irremediable impediment. Justice Edelman seemed to be the one who was most concerned about this. He considered that irremediable is not confined to permanent impossibility and could include laws that impose unreasonable obstacles upon renunciation. He did not think that the mere fact that foreign officials may exercise discretion would amount to an unreasonable law, but he observed, without deciding, that a law might be unreasonable in its practical operation if the process of renunciation had not occurred within 3 years or where a foreign official unreasonably refuses to exercise a discretion. So where does this leave Senator Payman? It's hard to say without knowing more facts. What law applies in Afghanistan, now that Taliban has come to power, about renunciation of citizenship? Does that law amount to an irremediable impediment? So, for example, would it prevent renunciation altogether? Or does it impose some kind of unreasonable condition in order to renounce? What if it just involves a long process with officials granted broad discretion? What if the problem is not the law, but the practical process of initiating the steps, such as the Afghan embassy in Australia not being able to fulfil its role? Is there any way of contacting the relevant ministry in Afghanistan directly to renounce, rather than going through the embassy? Does the embassy now act on behalf of the government of Afghanistan and initiate the renunciation process? I don't know the answer to any of these questions, and one would need to have a good knowledge of the law and practice in order to give reasoned advice on the issue. But it does raise an interesting question in terms of timing. What if there was an irremediable impediment at the time Senator Payman nominated because there was an unreasonable law, or no law at all, or no capacity to activate the legal process, but the situation later changed during her term of office? What if there is no longer an irremediable impediment and there is now a process under which renunciation can occur? Section 44 not only declares that a citizen of a foreign power, quote, shall be incapable of being chosen as a senator, but also that he or she shall be incapable of sitting. It has an ongoing application, such as where a sitting senator triggers one of the other disqualifications by becoming convicted of a crime or becoming bankrupt during their term of office. Section 45 of the Constitution also says that if a senator becomes, quote, subject to any of the disabilities, unquote, in Section 44, his or her place shall thereupon become vacant. So how would this apply if Senator Payman is a dual citizen who was initially subject to an irremediable impediment to renunciation at the time of nomination, but that impediment has since been removed? I don't know the answer to this. It would depend very much on how the High Court, as the Court of Disputed Returns, decided to deal with it. So will this question get to the Court of Disputed Returns? It seems to me that that's unlikely. Since the High Court rendered the common informer provisions ineffective, and that's another long story and I'm not going there for the moment, but anyway, ordinary folk can only challenge the qualification or disqualification of a Member of Parliament in the period of 40 days from the return of the election writ. Now that period of 40 days is well and truly over. So Senator Payman can enjoy her 6-year term without the fear of challenge from anyone in the outside world. The only other way to get this before the Court of Disputed Returns is if the Senate votes to refer the issue to it. Now this is what happened during the Section 44 crisis back in the period of 2017 to 2018. But since then, candidates are required to fill out that checklist prior to nomination, which declares various circumstances in relation to disqualification, including a whole lot of facts about citizenship. There was apparently an informal agreement amongst the political parties that as long as candidates were honest in their checklist, revealing all the relevant information, and they were not challenged in court within those 40 days after the election, then the parties would not seek to refer them to the court on disqualification grounds. Now, this is because the voters would have elected them in full knowledge of the relevant factual circumstances, and they would have had the chance to challenge them and had chosen not to do so. It seems to me unlikely that the Senate would seek to refer this citizenship issue to the Court of Disputed Returns now in the circumstances, and that the Labor Party would also find it somewhat difficult to do this, given that it actually endorsed Senator Payman's candidacy in full knowledge of the circumstances. But who knows? Politics is a hard game and it's not for the faint-hearted. Thank you again for watching the Constitutional Clarion. I hope you found this interesting and informative. And as always, I look forward to seeing you next time. Goodbye.